Chapter 6 is going to continue discussing defenses that a defendant would raise that they hope would either acquit them of a crime or lessen their culpability. Chapter 5 talked about justifications. In Chapter 6, we're going to talk about excuses. So excuses, some of them are what we call failure of proof, right? So failure of proof theory, these are defenses that excuse your conduct because essentially one of the elements that's present in the crime that the prosecution needs to prove, they haven't successfully proved. Technically, these aren't defenses because if an element of the crime is missing, then it's technically not a crime. Affirmative defenses, these are where the prosecution has proved the elements, so they've shown that those pieces exist, and the defendant has successfully shown an affirmative defense. So the prosecution proves the elements of murder, but the defendant tells you that they acted under duress. So insanity. We've got a couple of cases of insanity. Some are better known than others. Most of what people know about the insanity defense is incorrect. So in 1994, Lorena Bobbitt is found not guilty by reason of insanity. This is pretty rare for this to occur, but it's a very well-known case. If you haven't heard about this case, I would encourage you to take a minute to Google it and read up a little bit about it. We might discuss it in class, so please make sure you do that. 1980, John Smith is found not guilty by reason of insanity. He drove a Greyhound bus out of a New York City Port Authority terminal and crashed. This is a more typical case. It's not very well known, and he is actually still currently in the Manhattan Psychiatric Center, at least as of the writing of this text. Okay. So there's a little chart in our textbook that talks about some myths and realities about the insanity defense. And I would also really encourage you to make sure you read this over. People commonly think that the insanity defense is used quite frequently and that it's sort of an easy out for people. We also kind of have a tendency in our culture to say that, you know, people who commit these particularly heinous or atrocious or public crimes are quote-unquote crazy. Insanity is a legal definition. It's not a medical definition. You can't go to the doctor and be diagnosed as insane. And so some myths are that the insanity defense is overused, that it's limited to murder cases, that there's no risk to the defendant who pleads not guilty by reason of insanity, that they're quickly released from custody, that they spend less time in custody than someone who's convicted, that they're faking it, and that defense attorneys use it to beat the rap. So please take a minute when you're doing your reading to actually read through the reality piece of this chart. Insanity, as I mentioned, is a legal term, and it refers to someone's capacity to act, reason, or understand. There's a variety of tests or definitions that are used by different states that constitute insanity. But very few people claim it. Less than 1% of cases claim insanity, and it's successful very few of those instances. 26%, so remember, it's used in less than 1% of cases. In 26% of those cases is it successful. In 80% of that 20%, it's because both sides have agreed in advance. So it's pretty clear that the person is actually insane. Usually someone who successfully pleads not guilty successfully argues that they're insane, is civilly committed, and then they're committed for a really long period of time. Some states have abolished this defense, and other states have adopted this concept called guilty but mentally ill. Guilty but mentally ill is sort of a cop-out. If your mental illness is sufficient to negate your criminal intent, then it's not a crime. If it's not sufficient to negate your criminal intent, then it is a crime. What the guilty but mentally ill verdict does is it someone is still found guilty, but it forces the correctional system to provide treatment, mental health treatment. So this is some video about the Ronald Reagan assassination attempt, and you might want to open these PowerPoints on your own at home, pull them out of Blackboard and watch, actually watch this video. So the Hinckley case is pretty interesting. John Hinckley is somebody who was, he attempted to assassinate President Reagan in the 80s. And I'm actually going to save this case for us to talk about in class. But please do me a favor and actually read it over before we talk about it. So there's 4 different types of insanity tests that exist today. And we have the right-wrong test, which is called the Monotony rule. 28 jurisdictions use that. We have the volitional incapacity test, which is also called irresistible impulse, and that's only used in a few jurisdictions. We have the substantial capacity test. This is part of the model penal code, and 14 states use this. And this was the rule in the federal courts until the Hinckley case. And then we have the Durham rule, or the product test, and that is only used in New Hampshire. So our first extra credit would be, what insanity test does Massachusetts use? And that will be due on Wednesday, February 26th by 11 a.m. by email. All of the tests look at a defendant's mental capacity. The right-wrong test focuses on reason and cognition, and other tests focus on reason or will, or volition, which is basically the power to control their actions. In the right-wrong test, this comes from an 1843 case where Monotony shot Robert Peel. If you guys recall, if you're in CJ 101 right now, we haven't gotten to talk about Robert Peel yet, but Robert Peel is the founder of the modern police force, the Metropolitan Police Force in London, and it's why police officers are called bobbies. That's after Robert Peel, so in England, that's what they're called. And Monotony shot Robert Peel in a delusion of self-defense. He did not kill Peel, but he killed Peel's secretary, Drummond, by mistake. So he was suffering from a paranoid delusion that Peel had masterminded a conspiracy to kill him. And this is why this rule is called the Monotony rule. It's a 2-pronged test. So you're looking first to see that the defendant had a mental disease or defect at the time of the crime, and that mental disease or defect caused them to either not know the nature and quality of their actions, or what they were doing was wrong, or what they were doing. So one of the things that we see happen in cases a lot is how do we define these terms? So mental disease does not include personality disorders. So it does not include things like being a psychopath. That's antisocial personality disorder. Mental disease means psychosis, schizophrenia, paranoia. A mental defect refers to mental retardation or brain damage, severe enough that you do not know what you're doing or you don't know that it's wrong. No refers to awareness or cognition in some states. Other states mean understand or grasp the significance of their behavior. When we talk about the nature and quality of the acts, we're saying you don't know what you are doing. So for example, you think you're squeezing lemons, but in reality it's somebody's head. And as far as what wrong means, states vary on this. Is it legally wrong? Is it morally wrong? So you can start to see how something where we might look up a definition, we might look up a legal explanation, and it might look like it makes perfect sense to us, but this is why the law gets tricky. It's not always very clear. The irresistible impulse test is we can't hold someone responsible or deter them when they have a mental disease or defect that causes them to lose control. We're generally looking here at their inability to bring their actions into compliance with the law. So it's usually a supplement to the right-wrong test. So the person knows what they're doing is wrong, right? So instead of, in the previous case, we're talking about thinking we're squeezing a lemon, but we're squeezing a head. We're aware that we're squeezing a head, but I can't control it. I suffer from some mental disease that destroys my volition, my ability to control my behavior. And again, we're going to skip our case and come back to it when we have class discussion. The substantial capacity test, this attempts to remove problems of the not an irresistible impulse test. It emphasizes will and reason, and requires a lack of substantial mental capacity. So it doesn't mean that you lack complete mental capacity. It means that you lack substantial mental capacity. So somebody who has limited capacity may be found insane. A person is not responsible for their criminal behavior if at the time of such conduct, as a result of that mental disease or defect. Instead, here we're looking at lacking substantial capacity to appreciate the wrongfulness of their conduct or conform their conduct to the law. So intellectual awareness isn't enough to create culpability, and the second piece there sort of removes that sudden lack of control requirement. Again, if you recall, when we talk about mental disease or defect, psychopathic personalities, habitual criminals, people with antisocial personality disorder, those are not considered mental diseases or defects. And we want to think about this because while we use these terms when we talk about someone being crazy, we use them sort of to mean their behavior, meets a certain requirement. But when we talk about this, we're sort of implying that all criminals are mentally ill, and that's not really the case. The product of mental illness test, this comes from Durham v. United States, which is why it's called the Durham rule. This case codifies the right-wrong test because it considers knowledge and reason alone. It was only ever used in D.C., New Hampshire, and Maine, and now it's only used in New Hampshire. D.C. abandoned it after the Hinckley case. That's why Hinckley was found not guilty by reason of insanity. So this looks at acts that are the result of mental disease or defect and excuses their criminal liability. So in these cases, the burden of proof is interesting. So federal law at the time required the government to prove that Hinckley was sane beyond a reasonable doubt. The jury thought he was sane, but they weren't convinced to that degree beyond a reasonable doubt, and so they had to acquit. Since Hinckley, the government has required that the defendant raises the defense and prove they're insane, so that burden has switched to the defendant. So they bear the burden of production in presenting evidence, okay, and then they bear the burden of persuasion. Okay, so they have to persuade the jury that they are insane, but they don't have to persuade them beyond a reasonable doubt. They have to persuade them to a clear and convincing degree. Most states consider insanity an affirmative defense. So if you remember, that means the defendants have to bring up the issue and they bear that burden of production. They don't have the ultimate burden of persuasion to prove they are insane. So usually once they've met that burden of production, then the burden switches back to the state. States vary as to what that standard is. Is it clear and convincing, beyond reasonable doubt, preponderance of the evidence? So again, since we're looking at Massachusetts and what insanity test they use, let's see which one does Mass require. Diminished capacity is a failure of proof defense. The defendant will get a reduced penalty if they can successfully show this. So this allows the defendant to show evidence that negates specific intent and specific crimes. Usually we're talking here about premeditated murder. Okay? And what they would be arguing here is that their mental condition makes them incapable of forming the required mens rea. So here we're looking at an element of the crime, that the crime requires a certain level of mens rea to be proven, and they're saying that their mental condition makes them incapable of forming that level. There's a difference between diminished responsibility and diminished capacity. Diminished responsibility is where someone knows that they know what they did was wrong, but under the circumstances they're less responsible, so they're seeking to be punished for a lesser offense. Diminished capacity is really looking at a person's ability to commit the specific intent crime. Most states reject both of these. They may allow the court to consider it in terms of sentencing. And generally what happens is this would reduce first degree to second degree in a murder case, but it's pretty rare. So for our third extra credit question this week, let's look at, does math allow diminished responsibility or capacity? Okay, so that point is for both answers. So far we've got 3 points for this week. Age focuses on whether the defendant is too young. So this doesn't have to do with whether or not you were tried as a juvenile versus an adult. It's looking at whether or not you should be tried at all. Under common law, children under 7 had no capacity to commit a crime, and children over 14 had the same capacity as adults. Anyone between 7 and 14, it was presumed they had no capacity, but the state could provide evidence that shows otherwise. Today, the statute usually sets a specific age. It's often 14. Under that age, people are under the control of the juvenile court. Other states may grant the juvenile court exclusive jurisdiction up to a certain age. So this sort of varies by state. Most states place no lower age limit, so they don't usually place an age like that you must be at least 10, but they all place an upper age limit, and that's usually 18. Varies a little bit. Some states, there's 3 states that it's 16, and there's a handful of states where it's 17. In Massachusetts, it was 17 up until this past summer, and then it was raised to 18. Every state has a procedure for waiving juveniles to adult court, so that would allow them to be tried as adults, even if they're under the statutory age. Judicial is the most common, and then we've got prosecutorial and legislative. Hold on a second. But we talked about these in CJ 101, so they should be a little bit familiar to you. For a 4th extra credit point, what waiver method does Massachusetts use? Most states have adopted federal criteria that's been lined out in the Kent case. They look at how serious the offense is. Is the offense committed in an aggressive, violent, premeditated, willful manner? Is it an offense against a person as opposed to property? How much evidence is there? What's the sophistication and maturity of the juvenile? What's their prior record? And what threat do they actually pose to public safety? Today we check statutes to determine the minimum age of capacity. Some states, as I said, have no minimum age of capacity, and they could essentially take any child and hold them liable, and some states spell it out. In other cases, your textbook mentions, what about people who might be, quote unquote, too old to prosecute? There was a couple that was married for 50 years. The guy sent the wife out for bagels. He forgets them and brings back onion rolls, or she forgets them and brings back onion rolls, and he went nuts and axed her. The prosecutor declined to prosecute in this case. We also have behaviors that are criminal only for youth. So we've got a whole set of behaviors that are only an offense, a criminal offense for someone under a certain age. Truancy, running away, alcohol consumption, and in People v. Munoz, they look at the possession of a switchblade under the age of 21. All right, duress. So duress is also an excuse, okay? And duress is similar to necessity, okay? And it varies from state to state, but duress includes a threat of immediate harm, okay? And the threat comes from a person. So if you guys remember when we talked about necessity, we were talking about that necessity is not, the concern doesn't come from an actual person. It comes from some sort of, like, you know, a life-threatening situation or dangerous situation. In a case of duress, the danger that is posed to you is coming from a person. So threats could be specified, sometimes they're not. They have to be threats of serious bodily harm. It has to be immediate. We have to believe that the person making the threats will carry them out immediately. Some states limit this to certain crimes. and most states require a reasonable belief that the threat is real. So duress is an excuse and necessity is a justification. Duress, as I mentioned, involves the threat of injury made to a person. Necessity presents choice but doesn't involve a threat by another to commit the crime or else. So duress would be like if I put a gun to your head and told you that you had to, to commit a crime, or I was going to shoot you. Intoxication. Today we use intoxication as a mitigating factor in sentencing, and we also look at the difference between voluntary versus involuntary intoxication. Involuntary intoxication, this is when the defendant doesn't know that what they're taking could intoxicate them, or they were forced to take it. So in the 1915 case, Penman took what his friend said were breath mints, and in turn they were cocaine tablets. He killed somebody while he was high, and the court allowed this intoxication defense because he was not aware that what he was taking was cocaine. We'll come back to Burroughs v. State in class. Some states allow a defendant to show that intoxication negates an element of the crime, so it could show that your behavior was not intentional but rather reckless, okay? Entrapment, this is pretty interesting, and one of the things that this book in particular does well is it's going to provide us an example of two different cases that show us the fine line of what constitutes entrapment. So, as you know, our founding fathers were very worried about the new government becoming too powerful. There was a long history of people using secret agents for law enforcement. And so this is an affirmative defense that's created by law. Okay? And we have two approaches to this. We have a subjective test and an objective test. So the subjective test looks at whether or not the defendant is predisposed to commit that crime. So the defendant has to prove, right, so this burden falls on the defendant, that the government pressured them to commit crimes that they would not have done without the pressure. So here we're looking at where does the criminal intent originate, okay? So in Sherman v. U.S., we have a government informant and undercover agent. This agent meets Sherman in a drug treatment center, strikes up a friendship and asks him to get him some heroin. Sherman refuses. The government informant begs and pleads, and eventually Sherman gives in and gets him the heroin. So the Supreme Court, that should say SCOTUS, S-C-O-T-U-S, Supreme Court of the United States, found that the intent here originated with law enforcement, and given that this gentleman was in treatment, he wasn't predisposed to committing the crime. Government can prove someone's disposition to commit crimes in a few ways. They can show, has this person have a prior conviction for a similar offense? You can show their willingness to commit similar offenses. Did they have a certain level of criminal expertise in carrying it out? And their readiness. So usually when we're looking at these sort of cases, we're looking at consensual crimes. Syndrome defenses, this is where a group of symptoms or signs typical of a disease, disturbance, or condition. So battered women syndrome, PTSD. And we've got a PMS case here that we'll talk about in class. Post-traumatic stress syndrome, this is a defense that arises after the Vietnam War, but we see it to be an issue for people who experience a variety of traumas. The emotional and mental casualties that are more serious and lasting than physical impairment from war. So states that do allow it use it as a failure of proof defense or an affirmative defense. Okay, so for 2 more points and to end our chapter, does Mass allow PTSD as a defense? And if so, is it failure of proof or affirmative? All right, that wraps it up.